A city kicks churches out on the street. A state tries to force pro-life pharmacists to betray their faith. Activists want to redefine marriage. How's that First Amendment working for you? This is the Citizenlink Report. I'm Stuart, Shepard, along with our legal analyst, the guy who keeps track of courts for us, Bruce Hausknecht. Hi, Bruce.
Hi, Stuart.
First, let's talk about New York City. We're going to talk about 3 different court cases that are in different states of play, I guess is the best way to say it. First, we're going to talk about New York City, which more than a decade ago tried to kick churches out of public school buildings that they'd been renting on the weekends. And finally, a couple of weeks ago, they really were kicked out after a very long court fight, and one of them met out on the street.
All right. Well, I think I have good news on that front. Just last week, a federal district court granted that church and all other churches that are in the same situation an injunction basically ordering the school board to cease and desist from keeping them out.
While the case is being heard.
While the case is being heard. This is great news, and I think at least while this case is being decided, we've got some churches back in their buildings.
Now, make this just real. I'd like you to explain this for people like me, just so I can understand it, is what I'm trying to say. As we look at this whole thing, is it okay for churches to rent school buildings on the weekend? I mean, a lot of folks would say, well, wow, that sounds like that whole separation of church and state thing. What do you think?
All right. This goes back so many years, back to the founding fathers and their intent behind the First Amendment. The First Amendment's Establishment Clause, Free Exercise Clause, doesn't mean that churches must be kept out of schools. In fact, the judge in this case, the Bronx Household of Faith case, said, look, the Supreme Court's never actually determined that it violates the Establishment Clause to have a church meet in a school. I'm looking at it, says the judge, and I don't think it does. And it does not violate it, and therefore the school board has to demonstrate a compelling interest. And there's no way that it passes for that. And the schools have been arguing for years that look, we have to keep the church and state separate, and so we got to keep worship services out of the schools.
When they're empty on the weekend.
When they're empty on the weekend. And this judge is very pragmatic, and she looks at it the way you and I or any of our viewers would look at this issue. And I want to quote from the opinion, because she dispels the notion that a church meeting on a weekend in a school is going to send a message of state endorsement of religion. Yeah. She says this: the objective, fully informed observer who passes by the board schools and witnesses a wide variety of community groups meeting on weeknights, followed by a Jewish Friday night service, a Ramadan Saturday evening service, and finally a Sunday morning Christian worship service, could not reasonably infer that the board was endorsing religion in its public schools. Rather, the informed observer would conclude that the board opens its schools during non-school hours to a diverse group of organizations pursuant to a neutral policy generally aimed at improving the welfare of the community.
And the key there being, it's open to anybody, any community group of any kind that wants to rent the space. It's just a place for people in the community who pay taxes, that built the buildings to begin with, to meet together.
That's right. And the excuse that the school is raising, you and I can see through it. The people who live in those neighborhoods can see through that. They're not swayed by this notion that, a church meeting when no one's at the school would somehow convince the neighborhood that the school endorses religion.
Now, here's a question for you, and I've been wondering this. This case has been up to the Supreme Court, back down, back up to the Supreme Court. They didn't hear it this last time, which left an appeals court ruling in place, I think I'm getting this right so far, which said that New York City, the education folks, could kick them out of the schools. But now they've gone back to court and restarted the whole thing. How did they do that? It seems like once you lose the case, you're done.
Well, the interesting part is, for the first 16 years of this case, they were arguing about a First Amendment free speech right. We were talking at this table about viewpoint discrimination, and whether what the school board was doing was viewpoint discrimination. Ultimately, the school board amended its policy so many times that by the time last December rolled around, the Supreme Court had upheld the Second Circuit, which upheld the school district's policy. Yeah. But because the school district changed its policy, it looks like they've been hoisted on their own petard, as the saying goes.
Whatever that means.
Under the religion clauses of the First Amendment. They may meet the free speech clause,
Yeah.
but they have put themselves in deep trouble in trying to comply with the free exercise and establishment clauses. So it'll be interesting to watch that play out in the federal courts once again.
So the good news for now, if I understand this right, is they've started a whole new case based on the religious clauses of the First Amendment, the Freedom of Religion Clause. And because of that, the first judge has decided, you've got enough of a case here that I'm going to let you keep meeting in the school buildings while this whole thing goes through the courts once again.
That's exactly what happened.
All right. Now, meanwhile, in Washington State, the state had tried, they'd passed a law that pro-life pharmacists, all pharmacists, would have to dispense drugs that sometimes may cause abortions. This was a real problem if you're a pharmacist and you're a Christian and you're pro-life, and the state says you can't refer someone down the street. We got some good news on that front.
We certainly do. A decision came down last week from the federal district court there in Washington State, federal judge, who wrote an opinion that threw out this pharmacy board rule that bound these pharmacists. And again, the court, you could tell, was incredulous that the state had done what it had done. And just reading the first two sentences of the court's opinion kind of puts this into perspective. You can almost read the judge's unbelief at what they had tried to do. Here's from the opinion. This case presents a novel question. Can the state compel licensed pharmacies and pharmacists to dispense lawfully prescribed emergency contraceptives over their sincere religious belief that doing so terminates a life? In 2007, under pressure from the governor, Planned Parenthood, and the Northwest Women's Law Center, the Washington State Board of Pharmacy enacted regulations designed to do just that. Now, this is the governor in cahoots with Planned Parenthood forcing a state regulatory board called the Board of Pharmacy to enact rules that would quash the religious conscience of these pharmacists and the pharmacies. In fact, the governor went so far as to threaten to fire everyone on the pharmacy board if they did not write the rule that she wanted.
That's interesting. We've been having a pretty hot discussion on our Facebook page, facebook.com/Citizenlink. We encourage you to drop by if you're not watching this on that page already. We have some folks who are critics of pretty much everything we do, and they took issue with this whole thing and said, you know, you Christians, if you can't follow the rules, you should just find another line of work. This is not something for you. Now, interestingly, we had someone who's actually a pharmacist show up and made the case that he said, look, I'm not a monkey on the end of a rope. That's a quote from his post, where you hand in your prescription, you turn a crank, and I hand you drugs back. He said, it is a regular thing for me as a pharmacist to tell people, no, I'm not going to give you this drug because, for example, you might already be taking this other one, and there's an interaction that the doctor didn't realize, but the pharmacist did, and it could kill you if I put these two drugs together. He went on to point out that the morning after pill, as it's euphemistically called, that those emergency contraception, as it's also euphemistically called, on the description of when to take it and when not to, it says, if you suspect you may be pregnant, don't take this. So he won't dispense it because he says the label says not to do it.
Right. You know, that highlights another issue, and we've been having with people on the left who think that rights of conscience and rights of religious freedom have to be trumped by whatever the state wants to do about abortion, or to be even cavalier about possibly causing an abortion. This judge in this opinion said that the state argues that the plaintiffs, who in this case are the pharmacy and pharmacists, that plaintiffs' sincere belief about an issue at the core of their religion is not entitled to constitutional protection. But get this, but is instead granted or not as a matter of legislative grace. What he's saying is our rights don't come from God. They come from the state.
Oh. And
we can give them or take them away as we want. This judge was heated in his or her, I don't know if it's a man or a woman, but in his opinion, he was very heated about this.
And that brings up a fundamental difference of opinion that we're seeing in society about where our rights come from. The Constitution says they come from God. They're unalienable rights, as Thomas Jefferson wrote it. Others believe, well, as you expressed there, they come from the state, and if the state gives those rights, the state can modify them or get rid of them.
That's right. It's probably one of the hottest issues of our day right now.
All right, let's turn a corner here and talk about California. The California Marriage Amendment has been in court for a while. It got struck down at the Ninth Circuit Court of Appeals. What's the latest on that?
Good news. Last week, our proponents of marriage, protectmarriage.com and others, filed what's called a petition for rehearing en banc, which means they're asking for a fuller panel, an 11-member panel of the Ninth Circuit, to rehear the appeal. Okay. And throw out the decision from the 3-judge panel and hear it again and write a new opinion. And if they do that, that's good news, because obviously the 3-judge panel opinion was terrible.
I was talking to some of the attorneys who were associated with this at some distance just about a week ago, and they were talking about that decision whether to ask for an en banc hearing, a larger panel of judges to hear it, or to go straight to the Supreme Court. What are the advantages and disadvantages there? Why not take it on up?
Well, they were probably weighing a lot of different factors, from timing to who's going to be on the Supreme Court and what have you. But primarily, as a former trial attorney, I would look at it this way. I'm not going to foreclose any options. I'm going to go back to the Ninth Circuit, ask for this en banc hearing, and if I lose there, then I can go to the Supreme Court. I haven't lost anything. So, as a practical matter, I just want to keep my options open.
A little more case building along the way, if you will.
Exactly right.
All right. All of these, at least at some aspect or another, the first two perhaps more than the last, show that the courts are deciding the edges of religious freedom. How far does religious freedom extend?
It seems like on a weekly basis we're getting these cases.
All right. Well, thank you, Bruce, for keeping track of all this, and we'll be checking back in with you to get more updates as we go along. Thank you for watching. You may always write to us at mail@citizenlink.com. Remember to pray for all the judges around the country who have to decide these cases. Pray for clarity and wisdom and God's insight as they look into where our rights extend. And remember, stand tall and be heard.